Okay, we're starting the virtual, the Zoom, starting the YouTube live. All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Good morning, everyone. As everyone certainly knows, the COVID-19 pandemic has required our judicial system to make many adjustments in order to ensure continued access to justice. And so to address concerns surrounding that emergency, we have had to modify our procedures for oral argument. I welcome you to this remote proceeding of the District of Columbia Court of Appeals. It will be live streamed for public access. Court staff have made every effort to prepare the judges and counsel for the way that we'll proceed this morning, but we have learned through some recent experience that glitches do arise along the way. So I hope everyone will be patient and we will try to resolve them if they do arise. The public, meanwhile, may view the arguments in real time at the DC Court of Appeals website via the YouTube channel. There is a link to that on the website. And with that, we'll get started. We have one case that we'll be hearing this morning. It's number 19 CV0397, Animal Legal Defense Fund versus Hormel Foods Corporation. Counsel, are you ready?
Your Honor.
Yes, Your Honor.
Please introduce yourself and you may proceed. And I think from time to time, some of us may mute ourselves to reduce interference, but we'll try to remember if we're muted.
Good morning, Your Honor. David Maraskin for Animal Legal Defense Fund, which is the appellant and plaintiff in this case. I'd like to reserve 4 minutes of time for rebuttal if that's possible. ALDF has standing under both Article 3 and the K1C provision of the CPPA, as well as separately under the K1D statutory standing that's provided in the statute. But this court need not bother itself with much of the factual disputes and record disputes if it focuses simply on Article 3 standing. Under Article 3 standing, based on the facts found by the lower court as undisputed, ALDF falls cleanly within the standing for organizations that this court has provided under Equal Rights Center and a variety of other cases. Turning to the other holding that the court made, it's a preemption analysis. The lower court's preemption analysis violates Hornbook law. As Judge Thompson, you wrote in Murray v. Motorola, where a decision fails to cite any statutory authority for the notion that there's conflict preemption, which is true of both the lower court decision and Hormel's own briefs, then that decision is simply unpersuasive and cannot stand. Therefore, the two independent decisions holdings of the lower court are invalid, and this case must be sent back down. Turning specifically to Article 3 standing, I think I want to point you to this court's holding in Equal Rights Center, which said when an organization is forced to counteract the effects of another's unlawful conduct, it has Article 3 standing.
Now, counsel, I mean, in that case, there was some tester standing, though, right? They actually directly went out and investigated the particular violation. And here, what steps is it that ALDF took to combat this particular ad campaign?
So that's, I want to correct one thing about your question, Your Honor, which is ALDF under the law does not have to counteract the particular ad campaign. It has to counteract the effects of the ad campaign. That's what I was citing Equal Rights Center for, and that's what it did. As found by the lower court, as undisputed, ALDF is dedicated to providing consumers accurate information about how meat companies produce their products. ALDF went about this by petitioning the government to change how it regulates natural, specifically highlighting Hormel's misuse of the word natural. It then published that information to the public so that consumers would have that information. And when it found
But counsel, the FDA comments that you guys wrote were particular to labeling. You would have done that with or without the ad campaign that you're now targeting. Presumably you would have advertised the results that your FDA comment with or without the advertising campaign here. So I still have a hard time. I mean, it seems like a pretty tenuous hook to me.
Well, so let me give you a couple of case examples that are in tester standing to show you how this works. So if you look at this court's decision in Molovinsky and the DC Circuit's decision in Span, and that's written by then Judge Ginsburg, in both of those cases, there was discrimination by a private entity, a company. And what the courts in those cases found is that the conduct to educate the public that discrimination is not allowed, without even mentioning that company, just that because the discrimination that the company engaged in increased the need for that education effort, that provided standing. And that's exactly what's occurred here, Your Honor.
Now, my memory in Molovinsky was that the individuals, that the organization sent individuals in to interview. I mean, that seems like a much more direct link than what you have here.
So in Molovinsky, there's two separate.
You appear to have frozen. Mr. Green, is there something?
Go back and read the second half of that opinion. What it says,
Mr. Muraskin?
We missed a little bit of what you said. At least for me, the screen froze for a moment and we missed your comment. Could you start your answer again?
Sure, there's two separate holdings in Molovinsky. One is the tester standing that Judge Deal's referring to, and that's certainly accurate. But the court goes on and separately says that the organization's educational efforts provide Haven's organizational standing independent and apart from the tester standing that you reference. And again,
can I ask you a hypothetical then? So assume that ALDF's alleged basis for standing were solely the following. Assume ALDF said, we have in the past tried to educate consumers about what the proper understanding of the word natural is and what humane treatment of animals is. And now Hormel is putting out a misleading ad campaign on those topics, which is undoing what we have tried to achieve in the past. We have no plans to take any future action relative to Hormel. We tried to build our wall, and we're done with that. Hormel, though, is now ripping down what we created, the consumer understanding that we created, and we want an injunction stopping Hormel from doing that because it is, ripping down the wall of accurate information that we had previously constructed. Is it your view that that is a sufficient basis for standing, Article 3 organizational standing?
So that it would be much more tenuous Article 3 standing. We do specifically reference Hormel and say that we continue to plan on working against them, but under this court's decision in DC Appleseed, the answer would be yes. In fact, that this court, those facts are almost identical to what this court found was sufficient for standing in DC Appleseed. In DC Appleseed, the organization wrote a report that said hospitals should be giving more money to care for the poor. And what that report then led to legislation, and that legislation then led to implementation. And DC Appleseed disagreed with the implementation. It disagreed with how the state government was going to say that how much money needed to go to the poor, how much could be kept in reserve. And what this court said, and this is a quote, is that because that decision to give that less money needed to go to the poor would undo the dogged work of DC Appleseed, the report, DC Appleseed had standing. There, the report could not possibly have referenced that interpretation. It could not possibly have referenced the law because they were all pre-wrote it. The report predated everything else. Undoing the dogged work, this court has said, is the basis for standing.
Can I ask you we've said a variety, we've used a variety of formulations in trying to identify what it is that an organization has to prove to show organizational standing. And one phrase that we've used is direct conflict. Do you agree that for your client to establish organizational standing, it has to show a direct conflict between its mission and the allegedly illegal conduct that it is complaining about?
ALDF needs to show a conflict to the extent that it shows that it's not just trumping up these activities. That's
Guys,
what the
you
direct
dropped out the word
conflict-
direct, and I want to make sure whether that was inadvertent or whether that is you're trying to make a point in your answer.
I'm
Do you
trying to make
agree
a
that you
point in
need
my
to show a
answer.
direct do you agree you need to show a direct conflict?
I'm trying to make a point in my answer, Your Honor, that sometimes direct has been misunderstood to mean that there needs to be some kind of like magic word test. And that's not how it's actually been applied. What the direct conflict standard has meant, even though there has been a variety of formulations, like frustrate has been another formulation that's been used by this court. What the direct conflict standard has meant is that essentially this is not trumped up, that the organization actively, regularly engages in this work. And that, in fact, is Hormel's entire point here, that ALDF does that, because it told us it would do this anyway.
Counsel, I mean, it's interesting that you point out that we have used the word frustrate before, which is true. I think we have said frustration of interests, at least in one case that I can think of, might suffice. Doesn't Havens say exactly the opposite, though? A mere frustration of interest is not going to be enough for organizational standing?
Well, so this is where this language in all these cases becomes very confusing. There, what Havens is talking about is taxpayer standing. That, what DC Appleseed talks about is good governance standing. If the organization,
I disagree, counsel. I don't think that's all it's talking about. I mean, what we said in Appleseed again is that it needs to be. Let me just pull up the language real quick. I apologize. Never mind. I apologize, counsel. I can't find the exact language, but I mean, I'll tell you in DC Appleseed, the gestalt of what it says is, a mere frustration of interest is still not going to be enough. It needs to be sufficiently concrete and direct. It's things that don't sound quite so in the ether as you're putting them.
well, so what DC Appleseed also says is the organization just needs to be not neutral. And so, but I don't want to, I do want to emphasize, I'm trying to answer Judge McLeese's hypothetical. I'm trying to embrace it as it is, but the lower court here found there was a direct conflict. What the lower court found was that ALDF carries out its mission by seeking to educate consumers about truthful information about meat products. It's hard to see how, even if you use the word direct, Judge McLeese, that's not a direct conflict, and that's based on the facts found by the lower court, leaving aside the rest of the record that the lower court erroneously threw out. So, right, even if you were to disagree with me, Judge Deal, and we're talking about the edges of the doctrine here, we're clearly within the edges of the doctrine. And I would guess I would encourage you to take a step back and go to the basis of Article 3. Does ALDF have an injury? Yes, it's expended resources. Is that injury traceable to? And traceable is distinct from caused by, per the Rothstein case that we cite. Is that directly or indirectly connected to Hormel's advertising? Our injuries from having to spend resources to cleanse the marketplace, we're continuing to do that and have done that. About Hormel, I think even Hormel would agree that its advertising influences the marketplace of ideas about its products. And then, is ALDF's injury redressable? ALDF's injury is redressable because it's increasing its expenditures because of Hormel's misrepresentations. Certainly its advertising contributes to that misrepresentation, and partial redress is redress.
Can you tell me where exactly in the record is the best place, including in the affidavits or that the trial court viewed as sham affidavits, for a concrete explanation of what ALDF did because of Hormel's advertising?
Sure, I point you to the Dillard Declaration, which is A259, which should have come in but was excluded, and the Pouchet Declaration, A266, which came in. And what Pouchet explicitly says is that ALDF tried to educate the public about Hormel's misconduct so that the public could better make purchasing decisions.
You're using the word misconduct, and my question was concrete about advertising.
Well, so if ALDF worked to inform the public about what Hormel's products mean, and it did that at a higher level than advertising, but it's allowed to work at a higher level than advertising.
Well, the trial court's concern was that everything that ALDF was doing and indicated that it would do in the future was not so much at a higher level than advertising. It wasn't causally related to advertising because it was really about actual inhumane practices at places affiliated with Hormel, and about labeling, and that everything that had, this is the trial court's perception, I'm just trying to get your concrete response to it, that everything that ALDF, that was concrete, that ALDF said it had done, or that it concretely indicated it would do, was not causally related to advertising as such, but instead was related to other of Hormel's activities that ALDF objects to.
Well, so the Dillard Declaration, which the trial court erroneously threw out, explicitly says that this activity was motivated by advertising. So you want a direct response. That's the direct response. That affidavit should have come in very clearly. It does not fall within the sham affidavit doctrine.
I'm sorry, where is that, counsel? Where in the Dillard affidavit?
The Dillard affidavit can be found at A259 in the.
I know where the affidavit is. Where in the affidavit is that?
Oh, I can pull up the exact paragraphs for you. I don't have them in front of me right now, Your Honor, but he explicitly talks about the desire to work against advertising. I can find those paragraphs for you when I sit down.
Okay.
Before your time is up, let me ask you briefly about representational standing. Your opponent says that ALDF eschewed any notion that it was seeking to proceed on the basis of representational standing. So my question is, why would it be fair to allow you to rely on that to proceed in this case?
That's because, much like its natural claims, Hormel's playing a word game here. It's playing a word game about what we said. What we said was we're not seeking to file a Rule 23 class action. That's what we said in our removal papers. That's what we've consistently said.
Well, no, but it's more than just a word game, because they're pointing not only to what you said, but also to what you didn't say. Because in your complaint, you refer to subsection C in really all of the various filings up until the summary judgment filings. I didn't myself see any reference to subsection D as a basis for standing. So it's not solely what you said in the removal context, which I agree is can be viewed as more about class action than about organizational representational standing, or at least in part. But what about, is it accurate, let me ask you, that until your summary judgment filings, your client had never expressly indicated by any word that it was relying on subsection D and representational standing as opposed to organizational standing? So
I'm out of time, but I do, if it's okay.
Please do answer.
Yeah, so the answer, Your Honor, it depends on how we mean your question. If the question is, do we have a reference in our pleadings, subsection D, the answer is no. But if you look at paragraphs, and these I do have the paragraphs for you, paragraphs 31 to 34, and then 37 to 39 of the complaint, which is at JA 28 to 31, what we say is that we are seeking to represent, protect consumers, and we're seeking to protect the general public. And as Judge Thompson, again, I'll point you to your decision in Exxon, where what that decision says is if you allege the facts sufficient to make outstanding, then you can pursue that standing theory. And that's our premise of what is required by K1D. If this court finds that we need to pursue Rule 23 class action, then we have waived that. If this
but counsel, Judge Thompson, can I?
Yes, please.
All right, thank you. Thank you. So one thing that I assume Mr. Van Oort is going to get up and say is, we went through all this discovery. And if you were claiming K1D, there's this huge issue of whether or not you had a sufficient nexus to the consumer class. And we didn't get to explore that in discovery, not only because we weren't on notice of it, but because sometimes your witnesses shut down questioning about it because they said we're not raising a representational claim, only organizational. So, I mean, doesn't that strike you as hamstringing them a little bit and a little bit unfair to raise so late in the day?
Not if you, again, Your Honor, only if you believe that there is a Rule 23 requirement. I have no problem agreeing with you that we shut down questions about whether we were representing a class representative.
Counsel, I'm not talking about a Rule 23 requirement. I'm talking about what K1D2 explicitly requires, which is that your organization have a sufficient nexus to the consumer or class of consumers to bring the suit. And exploring that question strikes me as perfectly good fodder for discovery. And given your positions in the opposition to the motion to dismiss and in your pleading, it's not so clear to me that, and also given some of your witnesses' responses, it's not so clear to me they had the opportunity to explore that question.
Well, so Your Honor, I disagreed there. What we shut down, I fully agree, we shut down certain questions, but they were about whether we had a class representative. We allowed fulsome 2 years worth of discovery into what the organization does and whether it represents consumers. And that wasn't disputed below. The fact that we work on behalf to inform consumers is an undisputed fact found by the lower court. That's part of the record and not contested on appeal. That fact is what we say establishes that we fall within K1D, that we work on behalf of consumers. If you may very well disagree with my reading of K1D, and if that's true, then that is something different. But that's our reading of what K1D requires us to show, that we work on behalf of consumers. And Hormel got immense discovery on what ALDF does or doesn't do. Again, 2 years worth of discovery. And I would caution you against setting up a rule that this is about standing. This is about opening the courthouse door. And what Hormel's complaining about is that it didn't get the most internal workings of an organization, right? We can look to our documents to show what ALDF does. If you're gonna turn consumer standing into this roving exploration of every organization, if you need to go to the subjective beliefs of why the organization did something.
Can I just ask for one more thing? This is
Yes.
for when you sit down, counsel. Could you point me to the best evidence you have that they were focused on this question of the sufficient nexus, that they asked about it, and that you guys were forthcoming and answered it? If you could do that on rebuttal too, that would be helpful for me.
Sure, and I did while we were having an exchange, Your Honor, to find those sites. So paragraph 6, 7, 8, 9, all of the Dillon Declaration all talk about the specific focus on being on working against advertisements, but I will find you that other information as well.
Thank you, Mr. Maraskan. Does either of my colleagues have any further questions at this point? All right, well, we'll give you a little time on rebuttal, Mr. Maraskan. Thank you. Mr. Van Oort.
Good morning, Your Honors. May it please the court. I'm Aaron Van Oort representing Hormel Foods Corporation. ALDF's claims were dismissed for lack of standing in this case, not because of a disagreement over what the law requires, but because ALDF chose to pursue only organizational standing and then in discovery failed to show any injury to its organization. Now, when it filed the suit, ALDF alleged that it had taken all sorts of actions because of Hormel's deli meat ads. But when it came to discovery, the undisputed record showed that the only thing ALDF had done because of those ads is file this lawsuit. And that's not enough. More importantly, because ALDF is seeking only an injunction, what the record showed is that ALDF wouldn't change anything about what it's currently doing if the ads were stopped. To put it succinctly, it showed no injury to itself and no diversion of resources because of the ads. And it's the because of that's the critical link, and Your Honors were zeroing in on that, and I'm going to address directly.
Can you, counsel, before you do that, could you respond to Mr. Maraskin's argument about sort of what I would call the sunk cost argument that was part of Judge McLeod's question, that they have done this consumer education, they have engaged in that consumer education campaign for years, and that Hormel's ad campaign is causing a backslide and injuring them that way, in a way that seems to at least have a little bit of a basis, in our opinion, from Appleseed. Do you want to respond to that?
Yes, I'd be glad to, Your Honor. This case is very different from Appleseed. In Appleseed, it was an organization dedicated to creating first this nonprofit health insurer, and then making sure any excess profits from the health insurer went back to the community. And it got the law passed, and then after a decision was made requiring the profits not to go back, it objected to that and had standing. And so it had this very concrete connection to exactly what was at issue. And what's lacking here is that concrete reaction or connection between these ads and what ALDF has done. ALDF is definitely focused directly on animal cruelty and preventing that. It does not have a demonstrated record of talking about no preservatives and nitrates in foods and all natural meats without preservatives in foods. That's not its history.
Well,
And
a big chunk of its history, though, is trying to educate consumers about where their meat comes from and how it's raised. And they say what you're doing is making that enormously more difficult and causing a backslide from their previous efforts. Because now people are kind of masking what kind of meat they're putting out on the market, and that's hurting their sunk costs, basically.
yeah, Your Honor, that's what they alleged, but at summary judgment, it was time to prove that. And what they failed to prove is any connection of these ads on that perception of how the animals were raised. You know, we'll get to preemption later, but the whole point of this is that in the context here, the natural was referring to the meat, not the methods of animal raising, in separate terms there. And, you know, and so this is a dispute about facts at this stage. And
Can I ask you a question about law? Because
Yes.
more abstractly, I just want to see, do you agree that if adequately shown, a sort of sunk cost theory of organizational standing is legally viable? So assume that, again, when you say that there is a shortfall on the facts here, but imagine that ALDF alleged, you know, in the last year, we've spent, you know, $100,000 advertising, trying to let people know what natural really means and what the actual ways of production of meat are, and what, you know, what preservatives are added and how they're added and what a natural preservative should be understood to be. And imagine that then they allege that Hormel's ads are misleading and unlawful under the CPPA and are, I mean, again, in best case scenario for them in this hypothetical, let's say they bring in some market research that shows that in the last year, since Hormel has been running its ads, you know, understanding of consumers has decreased, and in you know ALDF's view of what a proper understanding of things would be. Is that, but assume they don't allege anything else they're going to do in the future. They just say, look, we spent a while building this, you know, wall of correct information, and Hormel is tearing it down, and we are aggrieved by that. We want that stopped so that it doesn't get worse. Is that a legally viable theory of standing under our law, DC Court of Appeals law, assuming it's adequately established?
yeah, I think that this court's law requires two things. It requires first an injury, and then it requires diversion of resources in response to the injury. So in your hypothetical, Your Honor, if the organization wasn't going to do anything in the future, I don't think it would have a diversion of resources, and so it'd fail for that reason. But what you're going to is just asking, would it meet the injury requirement in the first place? And your hypothetical is really close to the line, because this court talks about trying to discern between abstract interests, you know, like in just pure advocacy and a real concrete injury. But I think you're right that your hypothetical establishes the very best case that could make on that, would sort of be a test case where if they had been addressing exactly these issues, you know, like this is the foie gras cases, where they've been arguing opposing foie gras for a long time, and then a restaurant does something or an agency does something and they have standing on that. What you're doing is a test case there, and I think that would be a very close case under this court's precedent on that. But the problem here, of course, is that there's no demonstration of that, and the actual activities of ALDF showed that this wasn't really injuring them, and it showed that they didn't do anything in response to it on that.
So I ask you, in assessing the facts, it is significant whether we should be including the information that was in the post-discovery affidavits or whether we should be excluding them. The trial court excluded them under the sham affidavit doctrine. Can you explain, well, A, do you agree that they were subject to exclusion under the sham affidavit doctrine only if they were directly in conflict with some prior deposition testimony?
Yeah, Your Honor, I think what the district court accurately did is he didn't exclude them, but what he found is that they did not create an issue of fact for a variety of reasons.
Right. Exclude is an imprecise term, and I thank you for clarifying it, but
yeah.
Let me try my question again with a clarified term. When the trial court, do you agree that for the trial court to view them as inadequate to create a summary judgment issue under the sham affidavit doctrine, that's permissible by the trial court only if there is a direct conflict, to use the same phrase that comes up in the standing law, between what was said in a prior affidavit or prior discovery materials and what's in the depositions.
Yeah.
Or I'm sorry, vice versa, depositions and affidavits, sorry.
Yes,
That's just a
I,
simple legal question about is
I-
direct conflict the right standard to be applying here to invoke the sham affidavit doctrine?
yes, I agree that direct conflict is the right standard. There are two other reasons not to, why an affidavit may not be sufficient. One is that it's just too conclusory, regardless of any conflict. And the other here is the privilege problem, where ALDF invoked privilege and refused to answer the questions during discovery, and then came.
I got those separate, I have those separate points, but let me just focusing on the sham affidavit doctrine on which the trial court principally relied.
Right.
Could you explain to me what the direct conflict is between the any pre-discovery materials and
Right.
What is in the post-discovery affidavits? What's the
Yeah.
direct conflict?
Here's the direct conflict, Your Honor. In depositions and in the interrogatories, ALDF refused to answer the because of question. Did you do this because of Hormel's ads? And then it came back later and did it.
Well, I'm sorry, you mean to say that it's not a direct conflict between one thing that was said and another thing that was later said? There's a direct conflict between a refusal to answer and then an effort to answer belatedly. That seems to collapse the doctrine into what I thought was your separate point about unfair assertions of privilege.
Yeah, you're right, Your Honor. That's what we have. We don't have in the depositions or other things saying, no, we didn't do this because of the ads, and then a later assertion saying we did it because of the ads.
Well, it seems to me you're acknowledging then that there may be other grounds for the trial court's ruling, but that the sham affidavit doctrine, which requires a direct conflict, wasn't applicable.
Well, no, Your Honor, I think that is a conflict. When you refuse to answer and say, no, we aren't going to give this information, when we say, did you do this because of the ads? And they say, no, we aren't going to answer that. And then later,
do you have any law that would support the idea that the sham affidavit doctrine is applicable when a party initially refuses to answer questions in discovery and then later provides post-discovery information about them? I can see why that could create fairness concerns, but I'm not sure that it seems like a good fit under the sham affidavit doctrine. So I'm just wondering if you have any law that would apply the sham affidavit doctrine in circumstances that take that form.
Yeah, Your Honor, the two cases that we cite that are most directly on point are the NRA residential case and the Bright Harvest case in our brief. It's page 38 in our brief. And I can't recall whether they talked about this in terms of the sham affidavit or not. You know, and the district court did the same thing here. The district court said there are really three problems here. They're conclusory. And so even as I'm looking at them in the whole context, they don't create a fact issue. The second is it contradicted what they did in discovery. And the third was they invoked privilege and now they're trying to change their minds. And so exactly how that maps onto the different doctrines, Your Honor, the district court considered all three of those in its discretion. I think that was the right thing to do. And let me just be really clear about this. In the corporate deposition, and this is at pages 953 to 57 of the appendix, we asked the corporate representative precisely, did you submit the FDA comments because of the ads? And he refused to answer and directed on privilege. And we asked, well, did you engage in the Mashoff investigation because of the ads? And he refused to answer on privilege on that. And then on the going forward basis, Your Honor, because this is for injunctive relief, we specifically asked interrogatories saying, are you going to stop doing any of these things that you're claiming are attributable to Hormel if the ads are stopped? You know, what's the situation going forward? And this is interrogatory number 5. It's at the record in pages A372. And for every one of the things at issue here, what ALDF said is it was going to continue those as long as the activities happen. So for example, the ag-gag laws, it said it was going to continue opposing those as long as the laws were in place, which makes sense. It has nothing to do with the ads. For the swine swatter inspection rule, it said it's going to continue opposing that as long as the USDA allows it. It has nothing to do with Hormel's deli meat ads.
Can I ask you, I just want to run back something that you said. You were suggesting that part of the reason the trial court viewed the post-discovery materials is inadequate to provide, to create a disputed material fact was the refusal to answer questions on the topic and assertions of privilege about it.
Right.
Where in the trial court order are those things linked? The unwillingness to give weight to the post-discovery materials and the assertions of privilege about it. I know that that was an argument that was made by your client in the trial court, but I'm not finding immediately exactly where the trial court linked those two topics in the way that you're describing.
Yep, Your Honor, it comes at page A112 in the appendix. It's page 15. The trial court doesn't give any legal citation on this point, but what it says is it would be unfair in these circumstances to Hormel to allow ALDF to change its position at this
Right,
stage.
but the antecedent points that are made at 112 and 111 have nothing to do with invoking privilege that I saw.
No, Your Honor, I see what you're saying there, but this is the part of the trial court's order that responded to both of our points, that they're contradicting their depositions and they're changing. I mean, what we always said in the contradicting the depositions is that they refused to address it on privilege. And then later, after we couldn't examine it anymore, they came out and claimed that there's this causal link. And that's what the trial court is addressing here, and that's the unfairness driving it. And as I said, whether this is categorized under a sham affidavit because of conclusion and direct conflict, or whether it's the unfairness of a sword and a shield, the genesis and the core of the doctrine is the same.
Let me ask you this question, Mr. Van Oort. The litigation seems to have focused on three claims: natural, no nitrites or nitrates, no preservatives. But the complaint in this matter references some other terms that I guess were used in advertising. The one that sticks in my mind is higher standards.
Right.
Higher standard, I guess, is the phrase that's used. And it occurred to me that that phrase maybe has some bearing on both of the issues we've been talking about, or at least on standing and maybe on preemption too, because one might say that even if the claims about those other three terms were preempted, maybe ALDF ought to be able to complain about an advertising claim of higher standards, because maybe that goes to animal husbandry type issues. And someone might say, well, even if ALDF lacks organizational standing as to some of those other terms that are used, it didn't focus its activity on that. It has consistently been working for higher standards of raising animals. And I guess what I'm looking for is a sense of what happened to those other claims in the course of the litigation, because as I said when I started, they seem to have fallen out of the discussion. What can you tell me about that?
Yes, they fell out of the discussion, Your Honor, because ALDF didn't develop them in discovery. It didn't have its experts submit testimony on it. It didn't point to them and continue to rely on them. And so there's no factual record on that. And that's why we're just talking about the natural and the nitrates and the preservatives at this point. So it's the difference between a pleading and a factual record.
Counsel, I know we've taken you over time, but I would like to get your views on some of the representational standing points, if I could.
Yes.
So in their complaint, I mean, their complaint is rife with examples of how they represent consumers, of their advocacy work on behalf of consumers. And that was all relevant to the organizational standing point as well. So I guess my question for you is, given that you had every interest in trying to divorce ALDF from consumers, what prejudice was there to you in them raising their K1D representational standing argument late? And if the interest is just that you'd like to reopen discovery, did you ask to do that? And those are my two questions.
Yeah, Your Honor, the prejudice to us the prejudice to us came because of the conduct they took in discovery and refusing us to allow to explore that on that, because we asked specific interrogatories about associational standing. It was interrogatories 32 to 34. They appear at A76 to 78 of the record. And we asked ALDF to admit it wasn't pursuing associational standing. And it said, quote, ALDF admits that at this time it is not seeking to establish a standing based on associational standing. That's A77. So that's an admission that's done. And then we asked separately about representational standing. That was requests for admission 15 and 16 at pages A867 and 68. And ALDF admitted not knowing of any DC consumers that were misled by the ads. And then when we asked in their corporate deposition to identify any individuals that they said they were representing, ALDF refused to answer that question, saying it was relying on its organizational standing. That was pages A985 and 86 and A991 and 92. And so
Council, can I ask, do you think they need to identify, I mean, if somebody brings a claim under the CPPA that says, 80% of consumers are going to be misled by this advertisement. That's what our experts say. And Hormel has a huge market share in DC, and they sell millions of these products a year, making up numbers.
Yep.
Do they need to find somebody in order to bring a claim on behalf of a class of consumers, or is it sufficient for them to say the class of consumers is that class of consumers who we will establish has been misled, which will be 80% of the population?
I think you're on a subsection D allows both. It would allow them to represent either a specific consumer or a class of consumers. But the point there is that, as Your Honor noted earlier, there's a nexus requirement in order to prove adequate representation. And therefore, you have to be able to explore that and test whether that nexus and alignment of interests is met. And that's what ALDF refused to do here by not answering any questions about that alignment. And I want to go to 2 points, Your Honor, quick here. The prejudice is real. In this court's case under UMC development that we cite there in the case, it's at pages 44 and note 23. It was a similar situation where a plaintiff had relied on one theory of standing and then tried to change on appeal and said it should be allowed to develop the record further. What this court said is we hold that the developers may not on appeal rewrite the record they created below. The time to prove up standing is when it's in dispute, and ALDF has made its record now, and so it's bound on it.
And do you want to respond to Exxon, since that came up for the first time in their reply brief?
Yes, Your Honor, absolutely. And Exxon, the claim was brought by the District of Columbia itself, and the difference there was between a quasi-sovereign interest in enforcing your own laws and a sovereign interest. And what this court held is that the facts were plain from the beginning that the DC Circuit or that the District of Columbia was enforcing its sovereign interest. So all of the facts were there from the beginning.
I suppose my question is, why isn't that true here as well? All the facts that they are representing a consumer group, all the things that you would want to substantiate there are all in the complaint. I mean, they say, I think the word consumers and protecting consumers appears something like 100 times in their complaint, where they're saying, we are a group that what we do, how we achieve our mission is to keep consumers well informed and to make sure they get truthful information. That to me, which again is relevant to their organizational standing point, sure sounds like a lot like what you'd want to get at for the K1D2 prong of whether or not there's a sufficient nexus between them and the consumers that they're suing on behalf of. So I wonder if your answer to Exxon is there was enough to kind of substantiate the heel turn to a different legal basis of standing. I wonder if the same thing's not true here.
I don't think it is, Your Honor, because of the difference in what happened in discovery. And you're right that, K1C allows the general public, and this is the Consumer Protection Act. So of course you're always talking about consumers, but you're talking about them in the abstract and generally. The difference in the representational standing now is that you're not representing yourself. You're not representing your own members. It's something else. And what this court has said is that, and this is in Friends of Tilden Park, is that it's no small thing to allow an organization to represent somebody else entirely. And so you've got to be really careful to prove, and it said it requires the representational relationship to be a strong one to ensure the fidelity of the organization to those whom it claims to speak for. And what happened here is when you're under D and you're claiming to represent other people unconnected to your own group, you've got to be able to test how close the alignment of interests is there. And that means you get to get into discovery and who they're representing and what the fit is. And as I said to Your Honor, we tried that directly because of concerns that they would be allowed to shift under their complaint, and they shut it down. And at that point, if you've gone all the way through and you've used the judicial and private resources to set a certain record, you don't get to change it on appeal.
I know we're over time, but I did want to wrap back around and ask you one, what I hope is a straightforward legal question. And it's back on organizational standing. In concluding that there wasn't organizational standing, one thing that the trial court said was that seemingly as a flat rule, that the expenditure of resources on advocacy is not a cognizable Article 3 injury. Do you think that's a correct statement of this court's case law?
I think this court has walked right up to deciding that, Your Honor, and hasn't yet decided it. It's always found it didn't need to frame that because there were always grounds for deciding it different ways before that. And I don't think it needs to decide it here in this case. If you were pushed to that, I think the rule would be is that advocacy falls in the same kind of treatment for litigation as litigation, which is that you can't create your standing for the litigation or the advocacy you're doing simply by engaging in it at that time. There's a different rule just demonstrating a long-term commitment in the past. And as a continuation of this, I think that's the difference between, for example, the DC Appleseed case on the one hand and Friends of Tilden maybe on the other, and other cases on the other. In this case, the problem
is your answer that past advocacy might be enough, but post lawsuit advocacy or I don't know, post alleged illegal conduct advocacy is not enough? I'm just, again, the trial court seemed to say it as a flat rule. Our cases have some language that seem to point in a different direction.
I agree.
Are you suggesting that there might be a way of navigating all that by focusing on advocacy pre-complained of illegal conduct as opposed to post?
I think there's definitely a distinction between pre and post. I don't know that that answers the question, Your Honor, in all cases. Here's what I really think it's getting at, and it's hard because these are not concrete like numbers and lines. I think it's trying to get at the difference between an injury and an opportunity. You know, plenty of organizations spend resources all the time for things that they perceive as an opportunity. Zoom is investing heavily in this technology right now. That's not an injury, it's an opportunity. What's happening and what the courts look at in the context of advocacy and other things is, has this group demonstrated a consistent path on this, a consistent investment and efforts on this issue, so that when somebody else comes contrary to it, it actually is setting it back. And usually proof of that comes when the organization then responds specifically to that action that it says is a setback. If they don't respond specifically to it, it tends to show it wasn't really injuring them. It's something abstract. It's a social interest, but it's not injuring them directly on that, and it's not concrete enough to do Article 3. I think, as I read your cases, Your Honor, that's what the courts are struggling with when they're trying to figure out whether advocacy or past efforts are enough. I think that explains the difference between the testing cases, where it's specific and concrete enough because it's focused there, and some of the more pure issue cases. Here, this is more of a pure issue case for this. It's not a testing case because ALDF hadn't done anything on these ads before. It made no public statements about these ads until it filed this lawsuit, and it didn't change any of the activities it was otherwise going to do because of the lawsuit. This falls on the abstract interest side, not the concrete injury side.
Thank you, Mr. Van Oort. Mr. Maraskin, we'll give you a couple of minutes if you need them.
Yes,
I think you're, oh, okay.
Thank you, Your Honor. I want to respond directly to a couple of issues that Judge Deal and Judge McLeese sent me back to get at, but I think they're also tied to a couple of really important admissions you just heard. So what Mr. Van Oort just provided this court is a declaration that there actually is no conflict between the affidavits and the record, that there is no sham at issue here. Under that admission alone, this case has to be sent back down. The sham affidavit doctrine is a bold doctrine to throw out evidence. And what the precedent that we cite in our brief says is that if a court does so erroneously, that in and of itself is reversible error. And I will point you to some of the affidavits, Judge Deal, to answer your question about the why and how we answered the why we do things. But I also think Mr. Van Oort very clearly gave you an example himself, right? We were very clear. We're not pursuing associational standing, meaning we're not pursuing standing based on our members. We also were very clear, we were pursuing standing based on our organization's ability to represent the public in general and itself. And as you just, in your exchange with Mr. Van Oort highlighted, is that's the question about our interest in consumers under K1D is the same question about our mission-driven activity in this case under K1C, right? The mission that we are seeking to do is protect consumers. And no one is saying that that discovery wasn't allowed. And I'll
But
point
you, I mean, you better address his argument that, you guys actually cut off questioning on
Yeah,
points that would have
that's-
gotten to that. And so I assume what you might do to help me is give me an alternative explanation for cutting off answers to those questions, and or give me, the 100 times you answered them.
So I'll give you both, in fact, Your Honor. The reason, so the question wasn't phrased, were you doing this because of ALDF's ads? It was phrased as, why did you do this work? And because ALDF engages in a variety of legal work, the concern was that was getting at a variety of other legal activity that might have been related to the work as well. And so that was the concern, which is why the questions were cut off. But most notably, Your Honor, and this is where I think the 100 times we would have answered it, and this is in our reply brief, we specifically told Hormel that the person who was most knowledgeable about why this activity was undertaken, its motivation, and the resource diversion was Carter Dillard. He was the director of litigation and policy programs at the point the work that the diversion was going on took place, and the point where the litigation against Hormel began. And Hormel chose not to depose him. If Hormel's trying to hold us accountable for an objection, it needs to be accountable too for the fact that it chose not to depose him. He was
correspondingly, if you're the party with the burden of establishing standing and at the summary judgment stage, at least establishing a material dispute of facts about standing, it's a fair enough point that neither did you choose to provide until post-discovery information from Mr. Dillard. So,
but why would we, Your Honor, that's how this works, is that we tell them who they want to depose, that they get to depose who they want, and then when if we had put in evidence before the end of discovery, it would have been hearsay, right? If Mr. Dillard had randomly submitted documents, it would have been hearsay. It's the point that he either has to give admissions to the other side, which is admissible evidence, or he has to have a declaration, which is admissible evidence. And Mr. Van Ort's now admitted to you that the reason it was thrown out is totally erroneous. And Mr. Dillard did submit a declaration. The notion that Mr. Dillard's declaration is conclusory is disproven by just looking at it. It gets rife with dates, citations to the record, explanations. It's
We're losing the sound from you, Ms. Maraskin.
excuse me.
Did you move away from your microphone? It's difficult to hear you.
Oh no, can you hear me better now, Your Honor?
Yes, yes.
Okay. The notion that Mr. Dillard's declaration is conclusory is just disproven by his own declaration, is what I was saying. If you look at, this is Hormel's case, Daubert, which says a declaration that contains citations to the record should not be thrown out. Mr. Dillard's declaration contains citations to the record.
Can I get an answer to my question that is not so tied to the Dillard affidavit or the sham affidavit doctrine, because that's really not my question. Were there times when Hormel posed interrogatories or asked deposition questions that pertain to whether or not you could adequately represent a class of consumers, and your witnesses answered?
I guess it depends on what you mean by class, Your Honor.
Give me your best case. Take it the best way you can.
Well, I think we were very clear throughout. And I do think, to the extent, it sounds like Mr. Van Oort has also waived this issue, but to the extent that this court believes K1D requires a Rule 23 class, we were very clear throughout that we were not seeking to represent a Rule 23 class.
I don't mean that. I mean K1D2. Sufficient nexus to the consumer base. Did they ask you questions about that? Did you answer them?
The answer is yes, Your Honor. We repeatedly asked about our work. We repeatedly asked about our work to protect consumers. I'll point you, here's one that I'll give you as a concrete example, Pouchet. So Pouchet is a deposition. They don't claim there was any improper objection of privilege there, right? That's not one of the depositions that they claim there's any improper privilege objections. There's very little of that in the record. But what Pouchet testified to, and it's also in her declaration, and the reason I have her declaration, Judge McLeese, is that because that's how we put forward our evidence, but her deposition would be hearsay for our purposes. But her declaration is very clear that when you go to paragraph 9, that it's what ALDF is seeking to do is to empower consumers to be able to use information when making purchasing decisions. And that type of work is counteracting both the labels and the ads. And ALDF's allowed to do that. Hormel is certainly not making the representation here that its ads don't matter. And what the key for standing is did the ads increase ALDF's need to divert resources? And there's no question that the ads did that. If you go, the reason I keep on pointing you to the Dillard Declaration, Judge Steele, is that's where we explain exactly the connection between the ads and why ALDF felt the need that they were so significant. But if you're asking whether there's specific work to protect evidence about protecting consumers, look at the Pouchet Declaration. That was paragraph 9, I quoted for you. And I do, so, right, you have here this, I do want to respond also about this continued diversion, right? Again, the question is there a delta? Did Hormel increase the need to do something? And that the answer is with its ads, as I've shown to you in these areas, that it did, right? And that's always been considered sufficient. In both SPAN and DC Appleseed, it was well understood the organizations were going to continue to work in this general area. The question was, would their use of resources be directed by this unlawful conduct or not? And if they could free themselves from the use of the unlawful conduct, then they had more freedom for their use of resources. And you know, I think a really good example of this is the Humane Society case we cite for you. So in Humane Society, their injury was that they treated animals who were subject to fighting. And what happened was that because they treated those animals who were subject to dog fights and other kinds of fights among animals, they sued the US Postal Service for allowing the distribution of a magazine that promoted fighting. No one doubts that the Humane Society continues to treat animals who are subject to fighting. And no one required that the Humane Society reference the Feathered Warrior, which is the magazine, in its treatment of animals, right? What it was doing was it was treating animals. It was curing the marketplace that was created by the Feathered Warrior. And that marketplace would still exist without the Feathered Warrior. But by taking out that piece, the HSUS had standing because then it had more flexibility in how it spent its resources. And that's what that's what the Pouchet and Dillard declarations show you, Judge Deal. It seems like with the admissions here today that this case can simply be reversed on the record issue, but there is plenty here for standing.
Thank you, Mr. Mareskin. Thanks to both counsel for your arguments. The case is submitted and the court will stand adjourned.
This court is now adjourned.